abstract question of whether someone is generally a fit and proper person to hold an appointment in the organization. Because it is conceivable that someone may be considered to be fit and proper to hold some positions, but not others. For example, membership at a recognized bar is a necessary, but not in itself a sufficient criteria for a senior position at the NPA. And that point becomes very clear when one has regard to the relevant statutory provisions of the NPA Act. Possessing legal qualifications must mean something more than that one has an appropriate law degree. It means, in addition, that the person concerned has been enrolled as an advocate, having been found to have met the professional association standards in that regard. But the fit and proper test must also be considered with regard to the experience, integrity, and conscientiousness relative to the responsibilities of that office. And in her report on the fitness of Advocate Piccoli to hold office, which I've referred to earlier, Dr. Freni Janwala noted that in addition to appropriate legal experience, an NDPP must also possess managerial and leadership skills to enable her or him to effectively discharge their obligations. And her report states, and I quote, "The notion of integrity relates to the character of a person, honesty, reliability, truthfulness, and uprightness. Conscientiousness, on the other hand, addresses something related but different. It relates to the manner of application to one's task or duty, thoroughness, care, meticulousness, diligence, and assiduousness." She went on to state that there must be an appreciation of the significance of the role a prosecuting authority plays in a constitutional democracy, the moral authority that the prosecuting authority must enjoy, and the public confidence that must repose in the decisions of such an authority. It may therefore be argued that the test for fitness at the time of appointment would constitute an examination of the personal attributes of a candidate at that time, whereas the test as to whether an incumbent remains a fit and proper person when considering their removal from office embraces an examination of the impact of their conduct on the institution of the NPA as a whole, including public perceptions of it. And we would therefore say that a more stringent test should be applied when contemplating removal from office of either a Deputy National Director of Public Prosecutions or another senior official. We know that the decision to prosecute has to be taken in terms of the prosecution policies that are drawn up in terms of the Constitution and the NPA Act. And the Act adds important details to the constitutional provisions of the power to institute criminal proceedings on behalf of the state. At the very center of the decision to prosecute is the following statement in the prosecution policy document. Again, I quote, "In deciding whether or not to institute criminal proceedings against an accused person, prosecutors must assess whether there is sufficient and admissible evidence to provide a reasonable prospect of a successful prosecution. There must indeed be a reasonable prospect of a conviction, otherwise the prosecution should not be commenced or continued." When considering whether to prosecute and what constitutes being fit and proper to take such a decision, it should be noted that prosecutors do not base their decisions on the same considerations that judges may use, because a criminal trial is not like civil litigation in a different form. Amongst other considerations, the parties are not equals competing on a level playing field. In a democracy, the dice are intentionally loaded against the state, and this is fundamental to ensuring that the criminal justice system has public legitimacy. The task of the NPA is not to seek a conviction, but to put testimony before the criminal court if it is considered that there is a reasonable prospect that this will lead to a conviction, rebutting beyond all reasonable doubt the presumption of innocence. And prosecutors may base their decisions to prosecute on matters which are closed to the judges who may thereafter hear the cases. There are, in addition to the prior requirement that they must also consider factors such as the admissibility of evidence into the testimony that is to be submitted to the court, the credibility of witnesses, the respective strengths of the prosecution and defense cases, and the availability and reliability of witnesses and their testimony. The policy directives list and consider these points. And it is here that the matter of the prosecutor being a fit and proper person for the appointment takes on its sharpest relevance, because the factors which may fall to be examined may bear most heavily on the personal character and interests of the individual involved. The provisions of Section 32(1) of the NPA Act, which provides that the prosecuting authority shall serve impartially and exercise and carry out their powers, duties, and functions without fear, favor, or prejudice, must also be read in the context of the prosecution policy. And the first paragraph under the heading, Prosecution in the Public Interest, provides that once a prosecutor is satisfied that there is sufficient evidence to provide a reasonable prospect of a conviction, a prosecution should normally follow, unless public interest demands otherwise. And then in terms of, for guidance, when determining what the public interest demands, the policy instructs the prosecutor to consider all relevant factors and gives an inexhaustive list which includes the nature and seriousness of the offense, the interests of the victim and the broader community, and the circumstances of the offender. And these public interest issues may result in the prosecutors having a wide discretion, and one that must be exercised responsibly. The integrity and conscientiousness of the person exercising that discretion must be beyond reproach, and in the words of the Act, they must be seen to act without fear, favor, or prejudice. However, we know that there is a clear tension in this regard between the prosecuting authority and the executive, and this was exemplified in the tension that existed between members of the executive and the National Director of Public Prosecutions in the Vusi Pikoli matter to which I referred earlier. Advocate Pikoli was suspended from office by then President Mbeki on the grounds that there had been an irretrievable breakdown in the relationship with the Minister of Justice, and that plea bargains and the granting of immunity to members of organized crime syndicates was not in the public interest. In respect of the latter, however, the Minister of Justice has an opportunity to make an input when signing off on the prosecution's policy document, which requires the concurrence of the Minister, as this should set out the principles governing, for example, plea bargains and immunity from prosecutions. However, we would also say that in specific cases there would be nothing untoward in the National Director or a Deputy National Director consulting with the Minister to solicit the views of government on a particular high-profile matter, or to keep government informed of developments in such cases. However, what cannot be countenanced is the Minister seeking to instruct the NDPP on the exercise of their prosecutorial discretion, as happened in the matter regarding Vusi Pikoli. Under the heading Role of the Prosecutor, the following appears in the prosecution policy document, and again I quote, "A member of the NPA must serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law. They should not allow their judgment to be influenced by factors such as their personal views regarding the nature of the offense, or the race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth of the victim, witnesses, or indeed the offender." The second sentence of that, whilst it has a feel-good sense to it, must somehow be reconciled with the public policy issues to which I referred earlier. And prosecutors may be advised to seek guidance on precisely such matters as these, and They may be influenced by them, but they cannot be directed by them. The guidance that is supplied by the Code for Crown Prosecutors in England and Wales may provide some assistance in this regard. And it provides that the independence of the prosecutor is central to the criminal justice system of a democratic society. Prosecutors are independent from persons or agencies that are not part of the prosecution decision-making process. CPS prosecutors are also independent from the police and other investigators. Prosecutors must be free to carry out their professional duties without political interference and must not be affected by improper or undue pressure or influence from any source. This is a formulation which fairly describes the South African situation as well, and it means that whilst the NPA may pursue inquiries as considered above in order to reach a decision on whether to prosecute or not, what it gleans must never be treated as an instruction or an order to do so. That discretion must be protected and preserved. Moreover, by describing the independence of prosecutors from persons or agencies who are not part of the prosecution's decision-making process, it makes sense to talk of the concept of prosecutorial independence, as Dr. Jinwala did in her report and as the Constitutional Court did in the Similani case. In her report, Dr. Jinwala used words which resemble part of the passage that I've just quoted from the CPS, the Crown Prosecution Service, wherein she said, "The independence of the prosecuting authority is limited to the execution of its functions, importantly of deciding whether to prosecute or not to prosecute a particular offender." The Similani case also makes clear the necessary link between prosecutorial independence and the requirement that this prosecutorial independence empowers and must be exercised by only one who is fit and proper to do so. Whether one holds the prescribed qualifications for appointment to the office of the NDPP or the NPA must be assessed objectively. And in that case, the court said that a construction that renders the determination of the qualification criteria to the President's subjective opinion is not in keeping with the constitutional guarantee of prosecutorial independence. The interpretation that these requirements are objective jurisdictional facts that must exist before the appointment is made is more consistent with that constitutional guarantee. Prosecutors, be they the NDPP or deputies or directors, are not in the business of seeking public popularity, of being loved. They should rather aspire to be respected for doing the right thing. Their task is demanding and involves discretionary powers which require strength of will and unswerving resolution in the teeth of what may be fierce pressure, especially from members of the National Executive. The NPA Act carries us through to its logical conclusion. And in summary, we say that if the contemplated ground for the removal of the National Director or Deputy National Director is that one of these has ceased to be a fit and proper person to continue to hold office, the incumbent must be suspended by the President in order to facilitate an inquiry such as this. And by using such a mechanism of an inquiry, followed again by a resolution of Parliament, the authority and legitimacy of the office of the National Director, a Deputy National Director and Director are protected from the whims of a President acting purely subjectively. It is within the parameters of prosecutorial independence that the National Director, Deputies and Directors must exercise a discretionary decision whether or not to commence or to later withdraw proceedings. Where there is evidence that one may be unable to meet this standard, then such a person may properly be regarded as unfit for the office and not a person proper person to be appointed or to continue in that office. I thank you, Chairperson.
Thank you, Mr. Naidu. Thank you. But before we ask Council whether they have any questions for you, can we just take the opportunity to do that, so that if Council start talking to you, then they have the benefit of the questions that we will ask of you. Okay? Can I just, perhaps most of your questions will come at the end of or after Council has asked you some questions. You say, or let me ask it this way, what would the President have to take into account when she appoints, a president, when she appoints, let's say, a national director and her deputy, for example? What are the critical considerations which a president can or should take into account in order to respond to the notion of fit and proper? I know we have our constitutional requirements, but you might want to expand on the ideas which, or the issues which would feed into those constitutional imperatives. You understand what I mean? Thank you.
Thank you, Chairperson. I think the answer is partially provided in the legislation, which says that the fit and proper has to be a fit and proper test must be conducted in relation to the office concerned. So it's not an abstract concept of what may constitute fit and proper, which is why I drew a distinction earlier between fit and proper to be admitted to the bar, for example, and being fit and proper to hold the office concerned. So whether it be that of the national director or of a deputy, I think the importance of the powers of that office have to be taken into account. And that's why we say a much more stringent test needs to be applied in that regard, regarding the conscientiousness, integrity, and independence of that person. And the President, when considering for appointment a person to such a senior office, would need to take that specifically into account. And looking at the time of appointment, one would only be able to look at the previous experience of such a person, wherever they may have gained that experience, to try and assess whether they have demonstrated such conscientiousness, integrity, honesty, and integrity in doing their jobs, and in terms of the public profile that such a person may hold, and the esteem with which that person is held, because public perceptions cannot be ignored when one considers issues of independence. This is something that the Constitutional Court has spoken about in the Glenister case, that the considerations of independence are greatly influenced by public perceptions of that independence. So I think there's a whole gamut of issues that a president must consider in that regard, but all must be done in relation to the high responsibilities that are placed on the office of the National Director of Public Prosecutions as the ultimate body responsible for taking decisions in the institution of criminal proceedings in the Republic.
And talking about public perceptions, do you distinguish between public perception and public pressure? Public pressure which may be borne to bear on a prosecutor or prosecuting authority as presented in the media, for example, all levels of the media. And what role would that play with regard to the exercise of prosecutorial discretion? How is a prosecutor expected to conduct that discretion in the midst of public perception, negative or positive, and public pressure borne on her when she has to make a discretionary decision, either to prosecute or even to withdraw charges and lay charges. I just need to know what is expected in our situation, in the context of our constitutional imperatives.
Thank you, Chairperson. I think public pressure, as you put it, would be part of how one would interpret public perceptions. It can't be the overriding factor, but be one of many factors, because there would be interest groups that have a particular interest in one or other outcome of a prosecutorial decision, and that cannot be allowed to dominate the broader understanding of the issue of public perceptions. And whilst, as I said earlier, taking these tough decisions is not about a popularity contest. So sometimes one needs to go against the grain in order to do the right thing. And I think that's the kind of strength of character that is sometimes required to resist pressure, whether it comes from the broader public, or whether that pressure comes from, for example, members of the National Executive. And it's that ability to resist pressure and to be seen to do the right thing, even when that decision is unpopular, because in the longer term, that, in my view, would contribute towards greater public trust in the institution. One may disagree with a particular decision, but further down the line recognize that it was the right decision taken for the right reasons, even if one disagrees with it. And I think in that regard, this is where there's an onus on the person taking that decision to, at times, and obviously this cannot apply in every case, because it would inundate senior officials at the NPA. But they also need at certain times to take the public into their confidence regarding why certain decisions were taken in the way that they were taken. So to assure the public that the law and the Constitution is what was foremost, those are the principles that were applied to the facts in a particular case, and that the prosecutor has exercised her or his discretion with due regard to that constitutional responsibility, regardless of what a popular view within the public domain might entail.
I think for now, okay, Ms. Vilakazi has a question for you.
Mr. Naidu, I actually just wanted to find out from you, how does one balance the individual rights, the independence of the prosecutorial independence, and the protection of the integrity of the office, with regards to public perception? Because you end up having all these competing rights before you, which you need to consider at, arriving at a decision, or even from the part of anyone who's also watching, to understand how how these kinds of decisions one would have to look at balancing those competing rights at the end of the day.
Well, I think that that summarizes the the complexity and the onerous nature of the responsibilities that are placed on people who have to take these prosecutorial decisions. And I think, you know, the Constitution and the Act on the one hand provides a framework. I think the prosecution policy and directives provide greater guidance in balancing those different interests and ultimately taking a decision that taking into account all of those issues, some of which I canvassed earlier in terms of factors that may influence the public interest, take a decision that is on the balance in the public interest, or certainly in the opinion of the prosecutor, a decision that is fairly taken in terms of exercising the responsibilities that come with the office, which is a responsibility to pursue the public interest and to take a prosecutorial decision whether to institute or to discontinue a prosecution in that public interest. So it's a heavy responsibility, and a number of, as you say, competing factors have to be taken into account. But that's part of the difficult job that a national director or a senior prosecutor has to take, and that's why the responsibility and the standard of integrity and conscientiousness that is required of them is placed so high because of the gravity of the responsibility that is placed on that office.
Thank you.
Just trying to get some issues expanded on before Council gets an opportunity. You speak of influence and guidance. How do you see the difference between that in the exercise of independent discretion, particularly in the context of the hierarchical authority, different levels of authority in the NPA? When would a prosecutor be able to exercise independent discretion in the context of that hierarchy and determine that with regard to guidance, and when is it not influence? Or does it matter if a prosecutor is, through guidance, subjectively influenced by, so to say, her senior? Can you just say something about that?
Thank you, Chair. I think there is a significant difference between seeking guidance, canvassing a range of opinions in order to make the prosecutorial decision. As I said earlier, what cannot be countenanced is interpreting that guidance or that viewpoint as being determinative of how that prosecutorial discretion should be exercised. So whilst there would be, as I said, be nothing wrong in a national director seeking the opinion of the Minister of Justice, for example, or even the President in an appropriate case, but they cannot be purely reliant on that input that is given. That it would be one of the several factors which I raise in response to the question from Ms. Vilkazi just now, would be one of a range of factors to be decided. It may, and one would have to give due recognition to the views of that person, but it cannot be overriding. It cannot be seen to be dictating to the NPA how to exercise that discretion. This is an issue that arose in the example I used earlier of Mr. Advocate Vusi Pikoli in relation to the decision to execute the warrants of search and seizure and arrest of Mr. Jackie Silebi, where the then Minister of Justice, Bridget Mbandla, sought to instruct Mr. Pikoli to stop the prosecution until she had satisfied herself that there was adequate evidence to pursue. That was an abrogation of the rights of the prosecutor and went far beyond the responsibility of the minister. And, you know, unfortunately, this is a tension that has arisen in South Africa from time to time. And I think partly because of the confusion that is created in the Constitution, where it says very glibly that the Minister of Justice has final responsibility over the prosecuting authority. That is an issue that remains unpacked in the NPA Act and is therefore subject to different interpretations. And I think it is that constitutional provision that in South Africa exacerbates or has the potential to exacerbate the tension, in particular between the executive and the prosecuting authority.
How do we protect prosecutors, generally the NPA, from that potential risk of political influence? We've heard about the possible need to protect prosecutors in a way not quite dissimilar to the protection that judges enjoy in exercising their discretion for decision making against action, you know. Is it possible to provide prosecutors with some level of discretion? Maybe you're saying it by saying we need to unpack, you know, the constitutional imperatives, we need to unpack the NPA Act. But is there a way, or maybe what I'm asking for is, how do we, what's the need, how do we unpack, if the answer lies in that? But just tell us, is there a need to give prosecutors constitutional / legislative protection? Is it there? And we probably just don't recognize it, against prosecutors having, as it was said, to have to look over their shoulders every time they exercise their independent discretion the way they deem it fit. If the exercise of that discretion is going to step on the toes of some political authority.
Thank you, Chair. I think the protection of the integrity of the prosecutorial process is fundamental to the status of the NPA. It's fundamental to the strength of the rule of law in our democracy. So it's something that really does need to be safeguarded, and it needs to be done in a manner that, as you say, prosecutors are not always looking over their shoulder when taking a decision. And, you know, perhaps there needs to be broader discussion around issues of the prosecution policy. You know, this is a matter that is a document that is tabled in Parliament but never ever discussed in Parliament. There's no broader input into that process. Parliament just accepts the report and is not engaged with it. And perhaps if we had those kinds of broader engagements on what does a prosecutorial discretion entail, what are the factors that influence it, that we would have greater confidence of prosecutors in taking those decisions and being able to withstand pressure that may come against them from those in senior positions to them in the organization, or, as you say, outside of the organization. But on the other hand, I think there also needs to be a clearer mechanism of how to deal when prosecutors step out of line within the NPA. How does disciplinary action against a prosecutor who has failed to uphold the prosecution policy and directives, what action can be taken within the authority? We see, for example, another anomaly in this process in that a deputy national director or a special director in the case of this inquiry is not subject to accountability to the national director, and the only action that can be taken against such a person is through the President initiating a process such as this. And it would appear from the legislation that that's the only option that is open in terms of dealing with someone who is alleged to have transgressed that line of prosecutorial independence. So I think those are some of the issues that need to be dealt with in future in order to create a better framework for prosecutors within the NPA to know exactly how to exercise that discretion and what the implications are when they step out of line.
I think for now, that is all from me. And then we will give counsel an opportunity, if they so wish. And I don't know who will start first. Mr. Rib, or
if I may,
you?
Madam
Yes,
Chair,
you may.
Thank you very much, Mr. Naidu. There's nothing that I disagree with in your presentation. But it does seem to present the ideal in a democratic society, and we need to strive towards that ideal. I take it that you agree that the tests and the standard that you've expounded must then be applied to the facts of a particular case. In this case, the facts that's before the panel. I think the machine just needs to pick up your answer.
Indeed, I do. We sought to provide the framework for the panel to apply the set of facts and the evidence that has been presented here, which is why we have not commented on the facts of this particular case, but seeking to provide merely the framework in terms of which those facts must be understood.
And we want to say that we are indebted to you for presenting such a framework. It's extremely helpful. There's just some aspects that I would like to tease out. And the first one was obviously that the framework needs to be applied to the facts and to the evidence that's before the panel. Now, the chair asked you about the hierarchical framework within which prosecutors, and in particular the National Director of Public Prosecutions, and absent the National Director, the Acting National Director of Public Prosecutions operate. You recall that question? And yeah, just again for the transcript. Yeah.
Yes, I do.
Yeah. Now,
sorry, if you bring it closer to you, then you will remember to yes.
And even within the hierarchical structure of the NPA, you have a prosecutor anywhere in the country having to work with the South African police services, maybe even crime intelligence, maybe even IPID, and or the state security. So there's a range of institutions that are also involved. You'd agree with that?
I would.
In fact, no prosecutor can prosecute a case without there being a complaint to the police or maybe to IPID, and that complaint is then investigated, and the police will then open up a docket, and they will accumulate the information, and then present it to a prosecutor to decide whether or not to prosecute. That's normally how it works.
That's my understanding of the process, yes.
And then in the case of a National Director of Public Prosecutions, you have you have your special prosecutors in charge of special projects. You have your directors of public prosecutions. You have your regional heads. And then, of course, you have your deputies within the office. So it's a whole structure. Yeah.
Yes, there is.
Yeah.
Yeah.
So within that structure, I think the chairperson asked you quite a relevant and important question. In those circumstances, what role does independence play in relation to the NDPP or an acting NDPP or a deputy?
Well, obviously, the departure point is that prosecutorial decision is taken by the prosecutor concerned in the matter. But as the legislative framework provides, the national director has the ability to review that decision on occasion if she or he believes that it does not conform with the prosecution policy and directives and with the approach of the NPA itself. But that must be done within those parameters, so that there's not an untoward stepping on toes of people who take those prosecutorial decisions. And I think this comes back to the earlier question of the chairperson. It was what system needs to be put in place to ensure the integrity of prosecutorial autonomy at all levels of the institution.
Yes. Is it your understanding, and if you don't know the answer, fortunately you are protected today because you're not a witness, so you can say anything you like. But is it your understanding that the NDPP or acting NDPP or a deputy can mero moto intervene in a decision made by a prosecutor lower down the chain?
I would say not. There would have to be, I would assume that there would need to be prima facie grounds for them to be able to do so, and they cannot simply intervene willy-nilly. But I mean, I don't know the detail of it, and I don't, can't think of an example where that might have applied.
Yeah. Now, you would also appreciate and maybe even agree with me that there are literally thousands of cases that goes through the offices of the NPA weekly, monthly, yearly, and yes, a handful of them might be so-called high-profile cases. You'd agree with that?
Indeed, I would.
Yeah. And you will also agree that the NDPP or an acting NDPP, unless of course he or she can request it, there's no reason why, but they can't trawl through each and every docket or even one single docket that may constitute several lever arch files.
Indeed, that is the case. It would be unrealistic for that expectation to exist, and I think that's why one needs to have a robust framework within the NPA so that decisions are taken by prosecutors across the country on a consistent basis.
So you would agree, but on the basis of your response, that we need prosecutors from lower down right to the top to be persons of integrity?
Indeed, everyone in the NPA should be persons of integrity in order to ensure that there's public confidence in that institution.
And if there's an infection, as it were, lower down the chain, it could infect a decision at the end of the chain.
Potentially, yes.
Now, in a situation where the NDPP, and that's the evidence in this case would receive several views, opinions from persons in the office of the NPA on a particular prosecution. And the NDPP, and these opinions are conflicting. And if the NDPP decides to adopt or to embrace one particular opinion, would that compromise prosecutorial independence to base a decision on an opinion that he or she prefers over another opinion?
Not if the NDPP has applied herself or himself appropriately to those different views and has taken a decision on the basis of the legislative mandate of the institution. At the end of the day, a decision needs to be taken, and so long as that decision is taken in good faith and in pursuit of the constitutional mandate of the prosecuting authority, then I think that would be the correct way to go.
And that, because that brings me to a question that I wanted to ask you, and that is, what role does, and if you don't know often, I'll just remind you, Section 42 of the NPA Act provides immunity from prosecution to prosecutors, provided they act in good faith.
That's correct, yes.
So I can't remember whether you specifically dealt with prosecutorial immunity in the context of your framework and your analysis of how the panel should approach this issue.
No, I didn't deal with the issue of immunity at all.
Okay. So where a decision was taken, a prosecutor would be protected, i.e. not be liable under the Act, provided the prosecutor acted in good faith.
That would appear to be what the legislation says, and I think the overriding issue is there is that when a decision is taken in good faith, as I said, implementing the legislative and policy framework of the NPA, that would provide that defense. But if there's been a transgression of that policy framework, and if it is deemed that the person has not acted in good faith, then obviously that immunity will not apply.
So, if one factors it into your framework and into the inquiry that you suggested, and which I certainly agree with, the panel would have to also look to see whether, if any decisions, and there are, as you know, on the table here before the inquiry, one of the litmus tests would also be whether or not a particular decision maker acted in good faith or not.
Indeed, that would be a decision to be made.
So there would have to be demonstrable malefides. There would have to be a demonstrable act of bad faith in order to impugn the integrity of that particular decision maker.
Yeah, I mean, I think the issue is whether or not the person has acted in good faith in the execution of their legal mandate, and and that's a decision to be based on the facts before the adjudicating body.
And of a particular case.
And of a particular case.
And I know you're not a witness, Mr. Lawson, but we do value your expertise in evaluating these issues and spending a lot of your time giving consideration and doing research into this. But you would also agree that a wrong decision wouldn't constitute bad faith or malefides?
No, certainly, every decision might find somebody who would disagree with it, and it certainly would not in all cases constitute bad faith unless that was able to be proven. The words or
or the requirement of a fit and proper person appears both at section 9(1)(b), which deals with the appointment of an ND, of a national director and a deputy national director, and it also appears at section 12(6)(a) Roman 4. I may have missed it, but I didn't hear in your analysis or your framework that you distinguished between the two?
No, I didn't specifically.
Okay. I think because just for the record, or so that you can perhaps comment on it, section 9(1) says any person to be appointed as national director, deputy national director, or director must A, possess the legal qualifications that would entitle you to practice, and B, be a fit and proper person with due regard to his or her experience, conscientiousness, and integrity to be entrusted with the responsibilities of the office concerned. And then you must be a South African citizen, of course. Then 12(6)(a) Roman 4 deals with the suspension and removal from office. 12(6)(1) for misconduct. I think that's pretty clear what that means. On account of continued ill health. Then 3, on account of incapacity to carry out his or her duties of office efficiently. Or small Roman 4, on account thereof that he or she is no longer a fit and proper person to hold the office concerned. Now, where I, speaking for myself, just agree with you is that obviously when it comes to the 12(6) inquiry, the President, I think there was a question posed by the chairperson, the President will look at the impact that whatever events and circumstances and the facts of the particular case holds on your, or applied to your fitness to hold office, what you did and didn't do. Isn't that right?
That's correct, and I think what I said earlier is that the test to be applied when one is appointing a person, which would refer to section 9(1), and when one is considering removal from office would be different. The latter would be more stringent because it would be based on a very specific set of factors that give rise to one of those 4 conditions that is set out in section 12(6). So it's a much more focused inquiry when one is considering removal from office.
There are 2 questions that arise out of what you say there. The one is, would it still be 9(1)(b), fit and proper, i.e. with due regard to experience, conscientiousness, and integrity, to be entrusted with the responsibilities of the office concerned? Would that still be the test? And 2, I just want to ask you about what you mean, or just to unpack what it means to be more stringent. So the first question?
The test remains the same. It's fit and proper with due regard to the factors listed in section 9.
Yeah. By stringent and help us here, would it just mean that, I suppose when you're appointed, like Ms. Batoy, and you appear before a panel and you're interviewed, and you're asked these questions about your integrity, your experience, your conscientiousness, you would have served in some or other capacity as a private attorney or advocate, or you may have been in the public service as a prosecutor, and you would have testimonials and people attesting to your integrity and conscientiousness and your experience and so on. That's at the beginning, and of course you end up your certificate that you admitted, and you end up your ID that you're a South African citizen, and that's a, do you mean by that that's a fairly smooth ride when you get appointed?
Well, I don't think it should be a smooth ride. I think it needs to be it needs to be a robust interrogation.
Well, I think we saw in this round, which is quite frankly, as it should be, where there is a robust exchange, but in the sense that the test is lower.
Yeah, because I think, as I said in my earlier introductory remarks, at the point of appointment, one has to evaluate the candidate on the basis of their previous experience, which, as you say, may or may not be within the NPA. In some instances, NDPPs have been appointed who had no track record within the NPA, and then therefore one would have to evaluate them on the basis of their experience wherever else they had operated. Yeah. And that's, you know, and that's a decision that that the President is required to make in terms of the Constitution, and I think the Similani case gives us some guidance as to how that discretion ought to be exercised.
But contrast and compare that now with when you come at almost like the tail end, where there's a removal inquiry. We now know the NDPP who was appointed, or the acting NDPP, and there's a more rigorous examination and evaluation because of what you've actually done in that office or with that office.
Well, there would have to be a set of objective factors, for example, that would give rise to an inquiry such as this, that there is a level of dissatisfaction with the performance of the individual concerned that gives rise to the President instituting an inquiry under Section 12(6) of the Act, and the grounds for that inquiry would be made available, and the fit and proper test would be applied in respect of those complaints, if I can put them in inverted commas, that are laid against the individual concerned.
So I think you've answered just in terms of unpacking what stringent mean. It's not that the tests are different, 9(1)B, 12(6) or whatever it is. It's now applied to the facts of a particular situation.
Yeah, it's the test that is applied to a specific set of facts that now exist at the time when one considers the issue in the context of removal from office, which is very different from the objective factors that may have existed at the time of appointment.
Now, the chair touched on this. What do you mean by public perceptions? Would it be public perceptions shaped by who?
It would be an assessment of the impact of public perceptions on the independence of the institution as a whole, and obviously individual decisions that are taken by officials within the NPA contribute towards those public perceptions, and one would have varied public perceptions at any particular point in time as to the status and credibility of that institution in the eyes of the public. So it would be based on a range of factors and by canvassing a broad range of public views on that matter. As I said earlier, there would be specific interest groups that would promote a particular idea, which would compete against others, and it's a broad assessment of what public perceptions of the institution are, rather than, I think, of individual decisions. But individual decisions, on the other hand, have an impact on that institutional reputation.
Is it important for you and for CASAC that these public perceptions should also be shaped by the facts of a particular matter, the true facts?
Indeed, as I said earlier, was that even when the prosecuting authority that takes prosecutorial decisions that may be unpopular within the public domain, it should not hinder them from taking those decisions, because it's not a popularity contest. It's about taking the right decision for the right reason.
Would you agree that public perception is shaped largely, if not mainly or exclusively, by the media, the print and electronic media?
I think it may be in relation to certain high-profile cases that the NPA may be engaged with, but I think on the whole, given the role of the prosecuting authority as being the lawyers for the victims of crime in our country, that the experiences of ordinary people facing the legal system on a day-to-day basis would be an equally important factor in their perceptions of the effectiveness of the prosecuting authority. So somebody who's going to a magistrate's court as the victim of a crime would be equally affected and would have an equal impact on the public perception of the organization as a decision taken in a high-profile matter involving an influential person, be they a politician or business person. So I think one cannot separate the two, and public perceptions of this institution at the core end of it, which is where people are victims of crime, cannot be ignored in that equation.
I think we all accept that, and unfortunately, most of us have been at some stage the victims of a crime, and when in a personal or particular situation there hasn't been a prosecution, let alone a conviction, then people feel let down by the criminal justice system. So that is a on the ground shaping of a perception that, you know, the police and or the prosecutors are useless, or they corrupt, or they just don't bring the criminals to book. So that would be the one kind of public perception. But the other one is what I think most of us, especially as you say in the high profile cases, you open the newspaper and you read what is being published, and a narrative starts developing, and that would also shape your perceptions of the institution.
Well, I think what is portrayed in the media certainly has an impact on public perceptions. It informs to a large extent public perceptions of what happens, and I think a responsible, free and independent media is therefore critical in that regard. I think in any democracy, the public would not be aware of wide-ranging matters were it not for the role of an independent media to be able to put those issues before that public.
I agree with you. It's critically important that, again, a fearlessly independent media must also get it right, must get the facts right.
Absolutely, yes.
Because they do play an important role in shaping public perception.
Yes.
Are there any other? Thank you, Mr. Naidoo. I've got no further question. I'll see you at the next cricket match. Thank you, ma'am.
Thank you, Mr. Arendse. And we go to Mr. Rip. You are going to do it, eh?
Madam Chair, we don't have any further issues we wish to clarify with the submissions. Thank you, ma'am.
Thank you. Miss, you don't have.
Ms. Rajab Badnanda has got one or two questions that she's going to ask.
Or I give the panelists an opportunity again. Ms. Badnanda.
Thank you, Chair. Mr. Naidoo, thank you for your very helpful submissions. I have 3 questions that I'm hoping you can help us with. The first is, we talked about Section 42 of the NPA Act, and that provision, that section provides that no person is liable in respect of anything done in good faith under the Act. In light of Section 42, how do you balance good faith versus bad faith against the requirement of conscientiousness, which we know to be the standard of what is fit and proper? And I ask this because you could have a situation in which you acted in absolute good faith, but with a complete lack of conscientiousness. And what do we do in that situation?
Thanks. My view on this would be that I think, in a sense, that's why there's a range of factors that are provided in the Act in terms of determining fitness. So it's experience, conscientiousness, integrity, etc. And I think, as you rightly point out, that a decision may be taken in good faith as a result of a failure of conscientiousness, a failure to do one's job properly in order to reach the right conclusion. On the other hand, I think where there is a finding of bad faith, it would certainly speak directly to issues of not just conscientiousness but integrity as well, and would certainly undermine the perceptions of the fitness and propriety of a particular individual in that regard.
Thank you. My second question relates to something that you touched upon in section 179(5) of the Constitution. You described it as being an area that we needed to unpack and that was potentially problematic. I'm interested in knowing what your interpretation of 179(5) is, because it appears that 179(5) gives the executive a power to be the final arbiter, or not arbiter, but have final responsibility over the NPA. And it's not clear in what circumstances that is and how you balance that with the independence of the institution.
Well, my interpretation of that final responsibility of the minister would be that it must be interpreted within the constitutional design that creates the National Prosecuting Authority, that protects the independence of the exercise of prosecutorial discretion, hence the use of the example I had earlier of the Mrwebi matter, that it certainly does not include the right to interfere in prosecutorial decisions. I think it refers to the fact that whilst an institution or an organ of state can be independent, it must also be accountable. And it's the line of accountability that I think is blurred, because the Act talks of the accountability of the NPA to Parliament, as well as in terms of that constitutional provision to the minister. And we know that the minister, in terms of the Act, has other powers in terms of requesting reports from the NPA and so on. So I think there is a grey area there in terms of what is the clear line of accountability of the prosecuting authority, either to Parliament or to the executive.
Yes, and so one possible interpretation of that provision would be that that what's intended to be meant by 179(5) relates to things such as to a particular kind of accountability. So, for example, we know that the DG is the accounting officer for the NPA. That doesn't necessarily compromise the independence. It may, but it doesn't necessarily compromise the independence of the organization. Would you agree with that? So that the minister's accountability relates to something other than financial and fiscal accountability, for example?
Well, I think it can't relate to more than financial and management accountability of the institution. And I think, as we saw in the matter that led to the inquiry into Advocate Bikoli, it was the conflict that existed between the Director General of the Department of Justice seeking to interfere in the workings of the NPA that led to an unhealthy relationship between the National Director at that time and the Minister of Justice. So it's how one manages and interprets that accountability, and it has to be done in the way of ensuring, as you say, fiscal accountability, fiscal responsibility, without impinging on the independence of that organ.
Thank you. And my last question is on something that you dealt with towards the end of the questions from my colleague, Mr. Arnser, and it has to do with the notion of public perceptions. We accept that the importance and the role of public perceptions, as you discussed with Mr. Arnser, but my question is a little bit different. What impact does public trust have on the inquiry?
On the inquiry specifically.
Well, not on this inquiry, but on the question of the role of public perceptions. How do you balance public perceptions versus public trust?
Well, I think the one feeds into the other, and I think public perceptions can change over time. They would be influenced by different issues at particular points in time. But I think one can have an assessment of the general level of public perceptions of an institution over a particular period of time. And I think the prosecuting authority is one of those institutions where question marks have been raised about public confidence in that, which I think speaks to your issue of public trust. And I think public perceptions and trust are, looking at it from two different ends of the same, or looking at it from two different ends, because public trust really comes down to the issue that I raised right at the beginning, is about the strength and of our belief and our commitment to the rule of law, which is the basis of our society, and that's why the integrity of the NPA is so critical. In this factor, because it affects not just the issue of a prosecutorial decision in a particular case, but it goes to the very foundation of our constitutional democracy, which is the rule of law. And I think public perceptions in that regard play a really important role in determining public confidence in the rule of law.
Thanks very much. I have no further questions, Chair.
Can I just ask one last question? Yeah. Who and how are complaints against members of the NPA considered? Is it a self-regulatory setup, or is there?
I'm not equipped to answer that question, Chair.
You don't know?
No.
Yeah. Okay. Thank you. In the absence of any further interrogation or exchanges, I think we are indebted to you, Mr. Naidu. Oh, do you have? Masuku, you look unsettled. Or you wanted to answer that question for us? You don't have to. Yeah, thank you. You were considering it, but you don't have to. We really are indebted to you. Okay, you didn't have to come, but you were willing to do that. And speaking for myself, I think there are areas of enlightenment that I enjoyed from your presentation. Thank you so much. Okay.
If I may, Chair,
step down.
Just thank you again for the opportunity to share some perspectives with the panel, and we, as you say, I hope it is useful to you in your deliberations. Thank you very much.
Thank you so much. You may therefore step down. Thank you so much. And you're going to Cape Town? To Durban. Travel safely. Thank you. Ms. Bauer?
Madam Chair, as a matter of housekeeping, together with my colleagues, we have made a slight amendment to the further conduct of our proceedings. We would ask the panel for us to adjourn today. We would then have the submissions from Freedom Under the Law tomorrow morning, and we hope that we are able to start at 9:30 tomorrow. We apologize for the late start today. We would then have Advocate Rupp make his submissions thereafter. Advocate Arendse would then follow immediately, and we would hope that we would attempt to see if we can finish tomorrow. If not, that would then proceed on Friday morning. From the evidence team side, we would put in written submissions along the lines that we have maintained. We would basically do a summary of what has transpired, and we will make that available to the parties. And if there's any aspect of that that they disagree on, then they would like to request that they could then address that in writing with the inquiry.
Are there any time frame issues?
Well, we would consider putting in our written submissions probably on installment basis, ending on Monday or Tuesday, and then possibly give the parties a day or two to respond thereto. It depends. I'm trying to do an assessment of how much work we've still got to do, and you would appreciate that we've come off the back of 2 sets of cross-examination and considerable days of hearings in an attempt to pull all of that evidence together in a coherent manner, most helpful to yourselves. And so we are hoping that Monday, Tuesday we would see the light of day, but we would probably furnish part of it this week. We would do it in a subject matter on an installment basis so that you can proceed with your work on what we provide at that stage, and we'll give it to the other parties like that as well.
Do you foresee that we might stretch into Wednesday?
At the moment, not.
A response from Council?
Madam Chair, that the arrangement that Ms. Bauer has articulated to you is the arrangement we agreed. Obviously, we will wait for the evidence leaders to provide their summary of the evidence, and we'll take it from there, and hopefully it will be sooner rather than later.
Mr. Rip,
Madam
your
Chair,
position?
we can confirm that the position is as presented to yourself now. We're quite happy with that, and we trust that we won't need to respond, and if we do need to respond, it will be done promptly to keep the panel enough time to do their own work.
We are inclined to, as the panel, to probably give you a chance to stretch into Wednesday if needs be. Okay, but we hope that you'll be able to do it, all of it on Tuesday, instead of doing it. Yeah, okay, yes, thank you. So we adjourn
9:30
until 9:30 a.m. tomorrow. Mr. Rip?
We trust the further state
Mr.
machine
Arons,
will behave itself.
Yes.
We trust you.
I'm available at 7 o'clock tomorrow.
You're available. Yes,
I'm here in
yeah.
Gauteng.
Yeah, but welcome back from the Caster Semenya issues. We know that you presented as well. Okay, thank you. Thank you, everybody. See you tomorrow at 9:30.